Good morning. My name is Bob Wessels. I'm an emeritus professor at Leiden University. I will talk to you today about the recast of the European Insolvency Regulation. It's an introductory analysis, and of course it only concerns the EU. What it contains is a new version of the text of the Insolvency Regulation, which is itself some 12 years old. Article 46 said there should be a report for the amendments for a new regulation. The proposal from the European Commission was from 12/12/12, meaning 12 December 2012. And after some discussion with the European Parliament and the Council, last December, the recast of the text was published. In general, the proposal of 2 years ago had two main objectives. The first one is we found out that the regulation is operationally successfully, but there revealed certain problems. And one of the problems also was that current policies with regard to business rescue were not included in the old regulation. And the second objective is we want to improve the efficiency of European framework for resolving cross-border insolvency cases. And therefore, this is one of the main targets also in the recast. At that time, 2 years ago, the Commission said roughly there are 5 shortcomings. One is with regard to the scope. What insolvency proceedings are within the area of applicability of the insolvency regulation. 2, jurisdiction. Which court is allowed to open insolvency proceedings? We use the court of, for instance, the debtor, where center of main interest of the debtor is, but center of the main interest, COMI, gave a lot of problems. 3rd, secondary proceedings. If you have main proceedings in one country based on center of main interest of the debtor, it's possible to have secondary proceedings in other member states. But those proceedings have to be winding up proceedings, which is an awkward situation, and the Commission said we should resolve that. We should improve the rules with regard to publicity, transparency of proceedings, and 5, a topic that was not included in the regulation of 2000, there should be rules for groups of companies that have subsidiaries in several member states. So how to counter those 5 main shortcomings? First of all, the scope. We should widen it to, and revising the definition to include pre-insolvency and hybrid type of insolvency proceedings. The rules should clarify how to get more properly to the jurisdiction, so the basis for the court to decide. With regard to secondary proceedings, there are 3 items that were in the mind of the European Committee. First of all, the court in the other member state should be able to refuse the opening of secondary proceeding if this is not necessary to protect the interest of the creditors in that secondary state. Secondly, we abolish the requirement that secondary proceedings must be winding up proceedings, so there can be rescue proceedings. And thirdly, we improve the cooperation between the main proceeding in one country and secondary proceedings in other countries. With regard to publicity, the Commission proposed to publish the relevant court decisions, to provide interconnection between international web-based insolvency registers, and it also introduces standard forms that creditors can use. And with regard to groups of companies, there's also a proposal that oblige insolvency practitioners, which is a new word for liquidator, and courts involved in the different main proceedings to cooperate and communicate. So cooperation and communication is a main theme in the new insolvency regulation. Well, on today's agenda, I'd like to highlight some key points of what I call the recast of the European insolvency regulation. I'd like to compare the existing regulation and the new one, the scope of it, talk about jurisdiction, applicable law to those proceedings, what about those secondary proceedings, providing information and publication, how to lodge claims, some words on cross-border cooperation, groups of companies, and some leftovers and next steps, meaning when will this all come into force. And some of the slides may be not so well visible, or you want to read them again. The materials will be posted either on my own site or the site of the Turnaround Rescue and Insolvency Group in Leiden, and there you can find also other materials which are relevant to understand the insolvency regulation better. I will now make a quick comparison between the existing insolvency regulation, and the new one, the recast. The comparison is very easy. You may remember that there are 33 recitals for the existing regulation, and they have expanded to 83 recitals. The interpretation that the court gives to the rules of a regulation is purposive. What is the meaning of the regulation? What to achieve? And there several courts have used the report of Miguel Virgos and Etienne Smith of 1996. Now there is no such report. Purposive interpretation is still continuing by courts, but the recitals should provide further inspiration for the interpretation, and therefore the recitals contain some 20-25 pages. We go from 47 to 91 articles. We go from 3 annexes to 4 annexes. The first one stays the same. Annex A, all insolvency proceedings which fall under the scope of the regulation are mentioned there with their national names. And it will be the same Article 2, subparagraph 5 in the recast. Annex B was the list of liquidation and winding up proceeding of every country, but the secondary proceedings, but that has been skipped. So B gives room for, let's mention, all the insolvency practitioners that are appointed or working in those proceedings. Annex C used to be, and still is in the existing regulation, the list of all the liquidators, insolvency practitioners in the new word. Now it contains all the regulations that will be repealed. Many of those regulations are revising the annexes through the years by the introduction of new member states, Bulgaria and Romania, and it will also repeal the existing insolvency regulation. Then there is an Annex D, which is new, where you see a list of the existing articles of the insolvency regulation and where they are roughly in the new list of 83 articles in the regulation. And I've made my own transition and transposition table for the 33 recitals, where you find them in the 83 recitals in the recast of the regulation. Well, first of its scope. There was a lot of trouble to find a real value and idea about the definition of an insolvency proceeding. The requirements were easy if you were reading Article 1, saying it should be a collective proceeding, it should be based on the debtor's insolvency, it must entail the total or partial divestment of a debtor, and the appointment of a liquidator. According to court cases of the Court of Justice of the European Union, it said such a proceeding must be mentioned in the Annex A. And if so, it falls under the scope of the regulation, and it can benefit from the automatic recognition such a proceeding must have in other member states in the EU. The scope now extends to 8 types of proceedings. And you find it in Recital 10. Proceedings which promote the rescue of economically viable but distressed business, which provide for the restructuring of a debtor at a stage where there is only a likelihood of insolvency. So the pre-insolvency, hybrid type of insolvencies, which leave the debtor fully or partially in control, or which provide for debt discharge or a debt adjustment. The appointment of an insolvency practitioner, a requirement under the existing regulation, is not necessary anymore. The proceedings in the recast do not necessarily entail the appointment of an insolvency practitioner, but fall under the scope if they take place under the control or supervision of a court. And control means only that a court intervenes at the request of a creditor. There's only a light touch influence by the court. What it means is the introduction of a debtor in possession proceeding like the Chapter 11 proceeding in the United States. Then 5 and 6, proceedings which grant a temporary moratorium on enforcement actions from individual creditors, or proceedings which are subject to publicity. So no confidential insolvency proceedings can be recognized and brought under the scope of the new regulation. And 7 and 8, still based on the recitals, a proceeding that under the law of some member states are opened and conducted for a certain period of time on an interim or provisional basis, or which are triggered by situations in which the debtor faces non-financial difficulties. So we're far away from insolvency, provided, however, that these difficulties may give rise to a real and serious threat of the debtor's actual or future ability to pay his debts as they fall due. And this is the introduction of a large volume of case law, because what is a real threat and what is a serious threat, and what is the actual ability to pay and the future ability to pay. So if you want to earn your living, you better get yourself involved in this new regulation. The other requirements, so the appointed liquidator is gone, the divestment of the debtor is gone because the debtor can stay in possession. What are the other requirements? Well, you may remember Article 1 saying it should be a collective proceeding. And here recital 13 distinguishes. If it is a rescue proceeding, collective means that it is a proceeding that includes all or a significant part of the creditors. Is that 60, 70%, 85%, 90, 91? And to whom the debtor owes all or a substantial portion of his outstanding debt. So you have a number of creditors and a volume of debt. And if you have a liquidation proceeding, it should always include all the debtor's creditors. And so there you see collectivity in a liquidation proceeding. And the last requirement, only proceedings based on the debtor's insolvency, yes. Recital 15 says the regulation, the new one, applies to proceedings which are based on the law relating to insolvency. If there are proceedings based on general company law, not designed exclusively for insolvency situations, then it is not a law of insolvency. And the recast is very clear. It puts in the text of the regulation itself the proceedings which are under the scope, those 8, should be listed in Annex A. So no quarrel about that. The second issue is jurisdiction, the power of the court to take decisions. The idea with regard to center of main interest has been kept alive. And for companies, it is still Article 3.1 and Recital 29. For individuals, it has been amended a little bit. There are some rules on a more clear examination by the court whether center of main interest is indeed present. Specification of jurisdiction, so the argumentation behind the opening decision for opening insolvency proceedings. The possibility that creditors want to review that decision. There's a new line on that. And following European courts case law, jurisdiction not only to open insolvency proceedings, but for actions which derive directly from the insolvency proceedings and are closely linked to them, are now set into the text of the regulation, that the opening court has the power to decide on those issues. Now, with regard to companies and regard to individuals, you have to make a division. The text of the recast roughly reads the same. The courts in the member states, within the territory of which the centre of main debtor is situated, shall have jurisdiction to open insolvency proceedings. So they open main insolvency proceedings. The centre of main interest shall be the place where the debtor conducts the administration of his interests on a regular basis, and which is therefore is ascertainable by third parties. This is the text of recital 13, which is now taken into the text. Only the word therefore has not been taken on. And the presumption is, in the case of a company, the place of the registered office is the COMI, but that presumption only applies if the registered office has not been moved to another member state within a period of 3 months prior to the request of opening insolvency proceedings. So if a Latvian company established according to the law of Latvia, company law of Latvia, comes to the Netherlands, it has to prove that it is already 3 months or longer having its operational activities. Otherwise, the presumption doesn't work, and you have a free way of proving that a company's centre of main interest is yes or no in the Netherlands. For individuals, in the case of professionals, exercising an independent business of professional, COMI shall be presumed to be the individual's place of business, and there's the presumption also of 3 months. But in the case of individuals, the presumption only applies if the habitual resident has not moved for 6 months. There's a way to try to avoid abuse of the jurisdiction by just traveling as a consumer to another country. Right, some issues on applicable law, section in the present regulation from 4 till 15, not so much changed. What I think is worthwhile mentioning is Article 15 saying if you have a main proceeding in one country and there's a civil proceeding in a secondary country, then the pending lawsuit in that secondary country is decided by the procedural law of that secondary country, and that rule also is applicable for arbitration proceedings. And recital 65 is important because there are several provisions in the recast saying that the court has the ability to stay proceedings, and in the recitals it says any such say should not affect the rights in rem of creditors or third parties, so which is an extension of, you could say, of Article 5. Now, on secondary proceedings, I told you the 3 novelties. Abolishing the winding up requirement, a court may refuse the opening of secondary proceedings, and we should improve cooperation between main and secondary proceedings. Recital 40 says secondary proceedings may also hamper the efficient administration of a case. Therefore, the regulation sets out 2 specific situations that a court can assist in trying to achieve better efficiency. The first one is that the insolvency practitioner in main insolvency proceedings has the possibility to give an undertaking, a promise to creditors in another country that they will treat it according to the law of their country without opening secondary proceedings, but as if those secondary proceedings had been opened. And the other possibility, I will not deal with it, is that the court temporarily stays the opening of proceedings. It is my view that Article 36, the right to give an undertaking in order to avoid secondary proceedings, will be of massive importance in 3 or 4 years from now. 36.1 says, In order to avoid opening of secondary proceedings, the IP in the main proceedings may give an undertaking in respect of the assets located in the member state in which secondary proceedings could be opened, that when distribution those assets and the proceeds received as a result of their realization, he will comply with distribution and priority right under the national law that creditors would have had if secondary proceedings had been opened. And this is what's called in literature a synthetic secondary proceeding, or an as-if proceeding, or a virtual proceeding. The recast has 10 sub-provisions with regard to this undertaking. First of all, what law applies to it? Well, the law applicable to the distribution of the proceeds, the ranking of creditors' claims, and the rights of the creditors in that secondary state law. The requirements for language, for the form, it has to be approved by the known local creditors in the other country according to the rules that are there when secondary proceedings would have had opened. And the undertaking given and approved shall be binding for the estate. So the main estate is the main creditor. And there's a strong position for local creditors. The IP has to inform the local creditors how distribution will take place, otherwise they can complain. 36(8) says local creditors may apply to the court in the member state of the main proceedings also to complain and to ask for suitable measures. They can also make their complaint in the secondary court if it would have been there. And under 10, the IP shall be liable for any damage caused to local creditors if you don't comply with the undertaking. So my advice is you already start to talk with your insurance company whether the undertaking can be taken under the present scope of your insurance policy. On information and publication, there are some rules to establish insolvency registers, to interconnection of registers. Interconnection will be not on your cost, but on the cost of the EU. The information that has to be forwarded to that system, publication of an opening judgment or other judgment, registration of your judgment in a register of real estate in another country, and the cost of those registrations are incurred by the proceedings themselves. If you're a foreign creditor and you have a main proceeding in another country, you may lodge your claim in insolvency proceedings by any means, so just by email. And if they say in the other country, no, you have to go through a lawyer, no. Representation by a lawyer or another legal professional shall not be mandatory for lodging claims. There's a duty to inform a foreign creditors, will be done by a standard notice. There's a standard claim form for that foreign creditors, and there's a minimum period of 30 days that you have to file your claim in the proceedings that are opened abroad. Well, I already introduced an extension of cross-border communication and communication. The present rule is Article 31. There is communication cooperation between the liquidators in main and any secondary proceeding. But there will be new rules in the recast for cooperation communication between courts, Article 42, and between liquidators and courts. Okay, fine. Are there any rules for this form of cooperation? The recital says we should trust best practices that are present or from European and international associations, in particular relevant guidelines prepared by UNCITRAL. Now let's see, for instance, the new cooperation communication provision for insolvency practitioners. The first line in section 1 is roughly the same, and the second line says such cooperation between those two insolvency practitioners may take any form, including the conclusion of agreements and protocols. And protocols is a phenomenon coming from the US and Canada, which has been used 5 years ago in the global Lehman Brothers protocol, but this will be now, in 5 years from now, just a standard form on how to cooperate. Very important is the cooperation communication between courts. They shall cooperate, which in European lingo means you must cooperate. But if you don't want to cooperate and it's not compatible with the rules applicable for each of the proceedings, the courts may, where appropriate, appoint an independent person or body to deal with, on its instructions of the court, with this cooperation. And this is what the recast says about cooperation between courts. Cooperation may be implemented in several means. Why don't you cooperate the appointment of an insolvency practitioner in the two proceedings? So you have a Dutch proceeding and a German proceeding, and why will the Dutch court not appoint a German insolvency practitioner also in that proceeding in the Netherlands? Communication and information by any means considered appropriate, conduct joint hearings, and coordinate the approval of a protocol that has been concluded by insolvency practitioners when that is necessary. And with regard to cooperation between groups, the rules with regard to cooperation communication apply by way of analogy if there are groups of companies involved. The various IPs and courts are under a similar obligation to cooperate and communicate with each other, but the cooperation is differently, so the rules should have another focus. As it says, the cooperation is aimed at finding a solution that would leverage synergies across the group, which is differently than normal cooperation, where you are looking for efficiency of the proceedings. As I said, the recital refers to best practices that are available. One of the best practices is about 7-8 years ago, the European Communication Cooperation Guidelines for Cross-Border Insolvency Law, sometimes called the COCO Guidelines. But if you have seen, those are only referring for cooperation for insolvency practitioners. There's a crucial role for the court. And the last 2 years with the Nottingham Law School and the Leiden Law School, we have worked on a program that resulted this month, February 2015, in the EU Cross-Border Insolvency Court-to-Court Cooperation Principles. We call them EU JudgeCo Principles, including the EU Cross-Border Insolvency Court Communication Guidelines. We were not able to find a shorter version in the name, and these are the EU JudgeCo Guidelines. This is what the outcome is. They've been published and will be published these weeks. In addition to a review and advisory group of some 40+ experts from all over Europe, we had discussions and input from about 50 judges from all over Europe during trainings of a day and a half with regard to cases where you have to communicate, and in discussions with judges in other events. The JudgeCo cooperation principles are 26. The guidelines which you can use when you individually in a case set up communication then are 18. There's a small booklet, there will be a report, and you can find them on the websites mentioned at least as of March 1, 2015. The final issue is, which is new, is the groups of companies. There were no rules in the existing regulation, and there are 18 rules in the recast, which is a chapter 5, which is full and new. In Article 2, you find definitions for what is a group of company and what is a parent undertaking. There's a section on cooperation and communication, I just explained, and there's a section 2 on coordinating proceedings between a main proceeding and several proceedings that involve subsidiaries of a parent undertaking, procedural rules, and also the possibility to appoint an impartial, a neutral group coordinator. there are no rules for a uniform European rescue plan. Well, these were the main novelties in the recast of the regulation. Some leftovers, data protection rules, 5, a lot of issues, transitional and final provisions. There will be national and European insolvency law information provided by member states in a few years from now. Again, there's a review clause that the text, when it becomes law, will be reviewed in 5 years after its entry into force. The entry into force date is the normal one, 20 days after the publication of the official journal. That includes some 20+ European language versions of the recast of the European Insolvency Regulation. And then it shall apply, Article 91 says, 24 months after the entry into force. The current thinking is that all the texts will be available in March or April. So roughly in March, April, maybe May of 2017, the regulation recast fully gets into force. Thank you for your attention.